Hello, everybody. Thank you for having us today in this show with one of the attorneys in the law firm of Margaret W. Wong and Associates. My name is Juan Carlos Brando, and I'm really pleased to be able to host this show every Thursday at noon, at 12:30 actually. And thank you so much for joining us. Thank you so much for sending your questions. And please don't forget that you can call for more information. The phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call if you have any questions related to immigration, or if you want to ask about your case, if you want to ask about some situation that you have seen related to immigration. This is the good space that you can ask those questions. So let's welcome the attorney that is joining us today, Attorney Francis Fungsang. You all know him, and he's one of the awesome attorneys in the law firm who has more experience, has awards, and well, he always has a very clear answer for all of our questions. So let's welcome the Attorney Francis Fungsang, who is doing today an awesome show and giving all of the answers that we need. So thank you so much, Attorney Francis. How are you doing?
I'm good, thanks.
Well, it's always good to have you in the show. And today it's May the 11th. So I've heard that there's a lot of things happening today. So specifically about the Title 42, what's going on with that title and what does that mean?
Okay, so just to remind everybody, Title 42 was the healthcare policy where the previous president and the current president were preventing people from entering the United States across the southern border based on the COVID-19 pandemic. Now, the president announced that the pandemic has officially ended as of the end of today. And so that means Title 42 will not be a reason for the border officials to prevent people from coming into the United States. Instead, there's a new law that the president has issued that starts today that makes it a lot more difficult for people to enter illegally across the southern border and apply for asylum if they entered illegally across the border.
Okay, we have seen a lot of people entering in the United States in the last few months. And they have been discussing about the Title 42, if they have to remain in Mexico or if they can come in. So they have different point of views. But what is the difference between this Title 42 and this Title 8 that they want to implement, or that the press are saying that they are going to establish starting from now? What is the difference, and what are the advantages or disadvantages that we have with this new title?
Okay, so the new law that's going to be starting today, okay, assuming that there isn't a lawsuit by the ACLU or some other nonprofit to stop the new law from going forward, the new law that's starting today will make it more difficult. That means if somebody has entered the United States illegally on or after today, this new law will apply to them. Okay, so people who are already in the United States, this law does not apply. Okay. If you entered illegally across the southern border on or after today, you are not eligible for asylum unless you do certain things. Okay, so you're automatically not eligible for asylum unless you used the CBP-1 app to schedule an appointment to come to the border, or number two, you have an imminent threat to your safety. That means you'll be killed or raped or tortured. And that's why you had to come across the United States illegally. Okay? Or if you are an unaccompanied minor child, you're a child coming by yourself. If one of these exceptions does not apply, that means that you cannot qualify for asylum if you entered on or after today. So it makes it much more difficult. Oh, the fourth exception is you would have had to try to apply for asylum through any country you crossed. It's called the transit bar, because if you're coming from Honduras and you're coming through Mexico, you have to apply for asylum in Mexico and be denied by the Mexican government to qualify for this exception. Okay, so if none of these four exceptions apply to you, then you don't qualify for asylum in the United States.
Okay, and that's interesting because I was going to ask that, but you already mentioned that. What happens if I am from Guatemala, I cross Mexico, and I claim at the border that somebody wants to kill me in Guatemala? So what do I need to prove in this case?
Well,
Or I just don't qualify?
Well, you'll still be, if you claim a fear, you'll still be entitled to an interview at the border, but it's going to be more stringent because you have to show imminent threat. So if it's generalized gang violence, I'm afraid of the gangs, it's so violent, that's not going to be enough anymore. Okay? It's not just, do I have some believable threat against me? Is it imminent? If I go back, I'm going to be killed right away. Okay. And so I think you'll have to either have a very, very detailed story or bring documentation to prove what's going to happen to you or a previous threat against you.
Okay, perfect. Thank you so much, Attorney Francis, for this clarification, because we know that there's many people that are scared about this, that don't know what the difference is. And one of the difference that I've heard is that with the Title 42, you have a turn back, but with the Title 8, now you have a deportation. So what's the difference between these two?
Okay, so there's what's called a voluntary, when you come to the border, a lot of times you get what's called a voluntary return. You are not deported. So in the system, it doesn't show a deportation. It shows that they told you to turn around, turn back, go back. Okay, that's called a voluntary return. It doesn't harm you from coming back to the United States later on. But if you are subject to what's called expedited removal, that means that the Immigration Service deports you from the United States. It means you can't come back for 5 years. And if you do try to come back for 5 years, within the 5 years, illegally, that gives you a permanent bar. That means that even if you get married to a US citizen, even if you have US citizen children, it could prevent you from getting the green card in the United States. Okay, so this new law that starts today, it will make people who enter illegally subject to expedited removal instead of the option of voluntary return.
Okay, thank you so much, Attorney Francis. So just to close this matter, if I am in Mexico right now, I've been trying to do the CBP1 process. I haven't been able because the system is very slow. I haven't been able to make my appointment. What happens with me after today?
Okay, so this week, because of this new law and all these penalties, they realize that a lot more people are going to be trying to use CBP1. And so they have actually updated the system to have 1,000 appointments per day. And they're going to try to make this system better because they know that this is the one of the few pathways for people to try to come to the US legally. Okay, so hopefully the system will work and it's not going to be overloaded by so many people using it.
If I bring my kids with me, would I be returned to my country or would I be let in the United States?
Well, because those are not unaccompanied minors, they're with an adult, then it could be that everybody is subject to that expedited removal. So I think this new policy is definitely going to be a lot more risky for people to coming to the border illegally. We'll see, like I said, we'll see if there's a lawsuit filed to try to stop it. Most likely there is. It's just, it's probably going to take a little bit of time.
Okay, thank you so much, Attorney Francis, for this answer. And don't forget that you can call. The phone number is 216-279-3984, 216-279-3984 in the office of the attorney Margaret W. Wong. Let's start with the questions from our audience. And Robin is asking as follows. A person who was out of status for a year, currently on TPS, and traveled twice with advanced parole, is he able to adjust through green card spouse, has 4 years old, US born, daughter as well?
Okay, so this is a very good question because there's been a lot of changes about TPS over the past year. It's great that you were able to come back into the United States on the advanced parole. That means now you have a legal entry back into the United States. Unfortunately, that doesn't erase the illegal time that you've had before your TPS. So if you had any illegal time before your initial entry into the United States, the first time you came in, and when you applied for the TPS, if you had any illegal time, you would not be able to apply for the green card based on marriage to a green card spouse. But as soon as your spouse becomes a US citizen, then that spouse can petition for you and you can get the green card in the United States based on your TPS parole entry. Okay? So wait until your spouse becomes a US citizen, then you can apply.
Yeah, it says that this person was on F1 before.
So the person was on F1, and then if there was no break in the F1, you kept going to school, and before the F1 expired, you got the TPS. If you maintained your status that whole time, then your green card spouse can petition for you. Okay?
Okay, thank you so much, Attorney Francis. Don't forget the phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call to talk to one of the attorneys in the law firm of Margaret W. Wong and Associates. Don't forget that the phone number is for all of the offices nationwide in Atlanta, Columbus, Chicago, Cleveland, Nashville, Raleigh, North Carolina, and New York. And the phone number is just one, 216-279-3984, 216-279-3984. Next question. Hi, I am Colombian. When is starting the parole for Colombians? Is it the same as Venezuelans?
Okay, so this policy was just announced. Now, it's called family reunification parole. That means if you're from Colombia or Nicaragua or Honduras, and you are in the United States and you apply for some benefit, you can apply for parole for your family members to come to the United States to join you. Okay. Now, this was just announced very recently. And so there's no procedure in place yet. So wait until immigration makes more detailed announcements about the application procedure. It's probably going to be similar to the other family reunification parole programs that we have right now.
Okay, thank you so much, Attorney Francis, for this clarification. And some people are confused about these kind of applications. So is there a difference between the I-134 and I-134A?
Okay, so there are special parole programs, for example, for people from Ukraine, people from Venezuela. If there is a person in the United States who is a financial sponsor to submit this I-134, then you can sponsor that person to come into the United States legally. Okay. Now, the Immigration Service has not announced whether this new family reunification parole will go through this I-134 process or if it'll go through some other process. So we just don't have that information right
now. Okay. Thank you so much, Attorney Francis. We have another question here coming in. And this person says, hi, I am in removal proceedings, but I was victim of a crime and I'm waiting for EU visa. What do I need to do starting from now? Because I have this removal process, but I'm still waiting for my EU visa to come and it never comes. I filed 3 years ago.
Well, unfortunately, EU visas are taking maybe 5 to 6 years for immigration to process. It's a long time to wait. But the good news is, in the meantime, you've probably already received an EAD, your work permit, based on the bona fide determination. If immigration says that you've submitted the necessary forms, they will give you the EAD early. Now, because you have a pending U visa case, you can ask the court, the immigration court, or the government attorney in charge of your case to either administratively close your deportation case or to maybe even terminate your deportation case. At the very minimum, you should be able to get a continuance. That means to schedule a future hearing date, push out your case into the future, because it's a waste of everybody's time while you're waiting for your U visa. Okay? So one of those three options: get a continuance of your next hearing date, or try to get administrative closure, or try to get termination. Probably the best idea is administrative closure, because then you don't have to go back to court. It doesn't have to waste your time, the judge's time, or the government's time while waiting for the U visa.
Okay, thank you so much, Attorney Francis. Don't forget that you can call 216-279-3984, 216-279-3984. On YouTube, we have another question. Hi, how can I file for a student visa if I am outside of the United States?
Okay, so eventually you'll have to apply for the student visa called the F1 at the US Embassy or US Consulate in your home country. Okay, the very first step is you have to apply for admission at a US university or college. If you are admitted, the US university will give you a form I-20 signed by the university and signed by you, and then you will bring that form to your visa appointment at the US Embassy. Once you have that form, you create an online account on the US Embassy website in your country. You pay the visa application fee, then you schedule the visa interview. When you go to the interview, you're going to bring documents, including the acceptance letter and the form I-20 from the university. You're going to bring proof of your financial ability to pay the tuition and expenses. That means your bank account statements, proof you have a job. If somebody from the United States is going to be your financial sponsor, then you'll need a form I-134 signed by that person. You'll need that person's tax returns and proof of income, and a letter from that person explaining they're willing to be your financial sponsor. Okay. And lastly, you want documentation to show that you have ties to your home country, that you're going to go back to your country after you complete your studies. That means, do you have a home there? Do you have family there? Do you have a bank account there? Do you have a job waiting for you? These kind of things. All right.
Thank you so much, Attorney Francis. And I have some relatives that came on a student visa and now they are citizens. I don't know how they made it, but I guess an employer hired them and then they did all the process. But I know other people that have been here for 8-10 years on a student visa and then they have to leave the United States. Why would this happen? Why would this happen to one person that got the citizenship and the other that had to return to their country?
Well, when you were admitted as a student on the F1 visa, there's no expiration date on the stamp in your passport. It says D/S. That means duration of status. That means as long as you keep going to school, as long as you keep signing up for more education programs, you can theoretically stay in the United States forever. But that's very expensive, a lot of tuition, and you have to keep going to class. So eventually, after you graduate with your degree, you get 12 months of what's called optional practical training. It's a 1-year work permit to allow you to get experience or training related to your major. So that is your chance to find an employer willing to sponsor you. Now, there's two types of sponsorship. There's sponsorship for a temporary work visa, and there's the sponsorship for the green card. The most common way is you find a job using your work permit, and then you make sure that employer is willing to file the H-1B petition for you. The H-1B is the most common type of work visa, okay? And then if the employer likes you, maybe they'll start the green card sponsorship. The reason it sometimes takes a very long time for the green card is because if you are from China or India, there's a long line of people waiting for the green cards. And there's only a limited number that can be approved each year from each country. If you're not from China or India, the green card process takes maybe 1.5 to 2 years. From India, it could take 10 years. That's why it's important to find an employer who's willing to sponsor and get that H-1B so you can keep extending the H-1B and keep working here until the green card is approved. Otherwise, if you keep staying on F1, you have to keep going to class, keep paying tuition until the green card is approved. Unfortunately, if you can't find an employer willing to sponsor you either for a temporary work visa or for the green card, then unfortunately, a lot of people just end up going back to their home country.
Okay, thank you so much, Attorney Francis. This is a very good clarification about this situation. So if you have a student visa, I would suggest for people to do a good job. And when they are doing the professional, you said?
The optional practical training, or OPT.
Optional OPT. When they do that, they have to do a good job, because if they don't do that, then your employer or possible sponsor is not going to sponsor you, because you're not doing a good job. So you better do it and do it well. The next question comes from Pella. Says, my lawyer missed my first court hearing but came for the second hearing in immigration court. The judge said that the decision will be in 2023. Please, is this normal?
Okay, so as long as you showed up to court, even if the lawyer was not there, then it shouldn't be harmful to you. If neither of you showed up, then you'll have a deportation order because you didn't show up to court. But if you did show up, then the judge probably gave you another chance to see the judge again for your attorney to be there. Now, if you've completed your deportation case, that means you've completed your individual hearing. You've testified, the judge has asked you questions, the lawyers asked you questions, the government lawyers asked you questions, and your case is done, then the next step is for the judge to make a decision. Sometimes it's the same day, sometimes it's some day in the future. So the judge might schedule another hearing date this year to issue that decision for you. Either it's approving or denying your case.
Okay, thank you so much, Attorney Francis. And if you need more information, please don't forget to call. The phone number is 216-279-3984. And it's funny because I was talking to a Venezuelan person a few days ago, and he was asking me the same questions. What happens if I don't go to this court? What happens if I don't show up to this first court? Is it bad? Too bad? Can I fix it afterwards? Or is there a very bad consequence?
Most likely, if you don't show up to court, the judge will issue what's called an in absentia removal order. It is a deportation order because you were absent from your court hearing. It used to be sometimes people were getting lucky and the case was just administratively closed if you didn't show up. But these days, it's almost always a removal order. After that, you have up to 90 days to file a motion to reopen that deportation order and explain to the judge why you weren't there. Maybe you didn't know about the hearing. Maybe something happened, you were sick and you couldn't go. Maybe you did go, but you went to the wrong place. So you have to have a good reason why you did not show up to the hearing. Okay, it's very important that you reopen that case. Otherwise, it's a final deportation order. You could be deported by immigration.
Okay, thank you so much. And it's very important that we don't listen to people around there just saying, no, don't show up. It's not going to happen. Nothing is going to happen, and just show up to the second one. So it's not the same. You can show up without an attorney, and then you can ask for more time. But if you don't show up, this is the end. And we're just, the attorney Francis Fonsang mentioned that you can have a removal order in absentia. So you don't want to get that in your file or have a removal order because you didn't show up. Next question is, how long is a 601A waiver taking?
Okay, so the 601A is the unlawful presence waiver. If you are going to plan to apply for your immigrant visa, the green card, at the US Embassy in your home country, first you have to apply for the 601A waiver to forgive all this illegal time you've been in the United States. Unfortunately, immigration is being very slow. It's taking about 2 years for immigration to process those waivers.
Okay, thank you so much, Attorney Francis. And next question we have is, I am a religious worker. I am a pastor, but I'm here with an asylum case pending. Is my case changeable to another type of relief?
Okay, so if you're thinking about applying for a religious worker visa or the religious worker green card, so those are the two options. Religious worker visas is called an R1. Unfortunately, you have to have legal status to change to an R1. That means either you have B1 or B2 or F1 or some type of legal status. Having a pending asylum, you can't change from pending asylum to R1. So the only other way to apply for the R1 would be to leave the United States and apply for it at the US Embassy, but it's very risky because you've already have an asylum case pending, okay? Now, if we're talking about the religious worker green card process, that's based on I-360, the form I-360. Unfortunately, number one, it's taking very long for immigration to process these I-360s, okay? And you might have to wait in line for 4 years before you can apply for the green card. And number two, once you get to the green card application part of it, you have to show you have lawful status in the United States, or else you process the case through the US Embassy in your home country. Now, if you have an asylum pending, then that time the asylum is pending does not count as unlawful presence. But that doesn't erase any illegal time before you filed the asylum. And it also does not count as lawful status. Just like you can't change from pending asylum to R1 work visa, you can't just apply for the green card based on the I-360 with a pending asylum.
So in this case, this person is adding that he entered on a B1, B2 visa and filed asylum within a year of entering to the United States.
Well, unfortunately, so that means that your B1, B2 was valid for 6 months. And then if you applied for asylum within that 6 months, you might have a possibility. But if you had any unlawful time between the expiration of the B1, B2 and when you filed for asylum, that could be a problem for you. Okay. Now, let me mention one more thing. So there's the R1 temporary work visa. There's the I-360 religious worker green card. And then there's also perm or labor certification. So that's the EB2, EB3 process where it's the normal green card sponsorship from the employer, like we just talked about for students. That also could happen for religious workers. I-360, you don't have to do that, but you can go through the normal process for regular workers, and then the process could take maybe 1.5 to 2 years, but you still might have a problem with the very last step, the green card application, but at least you don't have to wait those 4 or 5 years like a religious worker.
Okay, thank you so much, Attorney Francis. And well, this is a very interesting time for immigration, but we only have 1 more minute. So if I have to ask you, as your opinion as an attorney, is this a good time for immigration? Is this a bad time? How do you see it from your point of view?
Okay, so it depends on your circumstances, unfortunately. That's the lawyer's answer. What are your circumstances? If we're talking about immigration as a whole, it's not a very good time because it seems like the administration is making it more difficult for people who are undocumented to get legal status, okay? They're making restrictions on asylum, which in the past is the only way for a lot of these people to seek safety or refuge in the United States. And it's definitely going to make it more difficult to get asylum, okay? Now, there are going to be other pathways legally to come into the United States, these parole programs, the CBP-1 app, but those are very restrictive. You have to be from a certain country. You have to have a certain circumstance. So I feel like the whole process is getting more restrictive for immigration. Employment-based immigration, investment, student visas, temporary visas, nothing has really changed for those processes over the years. That's all stays the same. So it's status quo for that. It's just everybody else, it's just making it more difficult for them.
Okay, thank you so much, Attorney Francis, for these answers and for clarifying all of the questions that people have. And well, we are really, really thankful that you have some time for us from time to time. We know that you all are very, very busy in the office, but thank you for these 30 minutes that you take some Thursdays to answer all of the questions that come in through our social media, through our Facebook Live, YouTube Live. And thank you so much for sharing your knowledge with us.
All right, I'm just glad to help.
Thank you so much. And for everybody who has joined us today, don't forget that you can call. The phone number is 216-279-3984, 216-279-3984. Attorneys like the attorney Francis Fons and with the attorney Margaret W. Wong and other attorneys that have been judges, prosecutors, they have been working in the immigration field for very, very long time. They are able to help you in your immigration case from the perspective of a judge, from the perspective of a prosecutor, from the perspective of an attorney. They can help you find a solution to your immigration case. Don't forget the phone number is 216-279-3984, 216-279-3984, 7 offices across the country, and you can just only call and they will find a way to help you out. 216-279-3984. Thank you so much. My name is Juan Carlos Brando, and have a good lunch.